G'day Nina, how are you?
Good, thanks Andrew, how are you?
Ooh, a lot to get through.
Yeah, it's a busy week this week, I think for us and also for Front Workplace Briefing.
Isn't it interesting how much has just changed in a period of 2 weeks, safety laws being turned on its head?
Yeah, new regulations coming into effect.
Yeah.
Well, sorry, not yet, but they are coming finally.
Yeah, 1 December. But the interesting part about it is I go out to chat to clients, I'm getting this incredibly odd response like, oh, it won't be like they say it's going to be. And I'm there going, why not? The Liberals haven't said we're going to say no. I think we've got to plan on the basis it is going to be like the original regs and codes because the Liberals took no offence with it at the time.
I think it's actually going to be harsher, given all the changes we've seen in the other jurisdictions.
Yeah, and look, the other part we've seen through the sentencing, which we're going to deal with the sentencing report that's come out, which I think is a really odd piece of thought that's come into it. There's some stuff which is sort of draconian on one level. There's some stuff which is restorative, but unusable at another level. I think sometimes when experts get hold of stuff, they don't actually think what it looks like in practice.
Yeah, they haven't thought about practicality. Like, I understand where they're coming from. Like, the aim is to reduce safety incidents, which we all want, but I don't know if this is really how it's going to be tackled.
They've got a healing idea in it. They've got an informal alternate pathway to prosecution. All sounds good, but it already takes 2 to 2.5 years to get to court. What they're suggesting in every part of the step, we could be there 4.5 years later dealing with the same issue. There's no healing in that. Anyway, we'll get to that, won't we? You can see I'm going to get fired up nice and quick. Why don't we go to our first case? This is the Sydney Trains case. It's a suspension of a bargaining process where a union started to lose control of its members, where there'd been bans and partial bans, and individual members were running rogue. We've been interested to know actually what does happen with the new bargaining amendments, because they were designed to make it harder to suspend bargaining that was going on, harder to stop industrial action because it was driven from a union narrative. But it's interesting, when the union gets in trouble like they did here, Fair Work Commission jumped in straight away and said, yeah, look, we'll give you a bit of time because the trains aren't running. And by the way, you've lost control of your members, so if we put it off until July, maybe you can get control of your members again.
Yeah, it was pretty funny. It was like a whack on the head, being like, get your affairs in order, really. Yeah. No industrial action until July 2025.
So, and the effect of that will be that the union can come back and say, you guys are doing unlawful action. If you keep doing it, you'll actually get terminated and we can't protect you.
Yeah.
Okay, because unlawful industrial action is a fundamental breach to your contract. It's only legislation that makes it allowable.
Yeah.
So interesting stuff, and interesting how both unions now are using bargaining, suspension of bargaining. So an interesting case, but really just for fun, we wanted to tell you about it, okay? Why don't we go to our next case? So the next case is RLS and RigSafe, okay? This is
enterprise bargaining case.
Look, how tired are you of enterprise bargaining cases where the employer fails to get notice of employees' representational rights out, fails to give some employees the agreement to consider, and then chooses who will vote based on who's present?
Yeah, and then yet, despite doing all of that, still lodges it for approval, not thinking that the union is going to object because there's no genuine agreement.
Now, so have a guess what happened. There's no genuine agreement, back to the drawing board. Dumb stuff, like there is a procedure. Nina can actually give you a tick list to go through if you want to know what it is, but there is a very simple procedure you've got to go through, and if you don't follow any part of that procedure, it'll be chucked out and you've got to start again.
Yeah, because the failure to provide a notice of representational rights is a fundamental breach of the procedure. Like, there is that new...
Can't be cured.
Yeah, that legislation which says, for small defects, they can ignore it and approve it anyway. But without an NERR, you're stuck.
And the same thing, if you don't give somebody the actual agreement and you don't go through that agreement, it's fundamental. It's the end of the agreement. Yeah. And I just want you to understand what that means. I'm sure you all do understand, is that agreement is torn up. Those months of negotiation are torn up. You've empowered your employees because they've been cheated by you. You're not going to get the same agreement voted up when you come back. It's going to be better for employees. So it is Dumb and Dumber. All right, I want to go on to our next case now. Nina, University of Tasmania and Jasing.
Yeah.
Tell me about this case. This is
terrible.
I have some very strong views about this case. I'm sure you do as well. Maybe you give us a few of the facts and then we just jump into it, eh?
Yeah, so this was a case where the university lecturer had been sexually harassing one of his students who was working on a research project with him.
And can I just say, let's stop and say what that sexual harassment is, because I think it's worth stopping now, because there's a decision that's made within the university which is inexplicable that follows this. Regularly requiring a research student to meet outside of hours.
Despite her objections
Despite her objection. CCTV showing he regularly touches her.
Yeah.
And obviously the differential in power. They're just some of the parts of it, but I mean...
And he said that if she didn't reciprocate, he would make her life on the research project extremely difficult.
So there you go. And by the way, you'll find shortly that somebody thought that wasn't sexual harassment. Over to you now, Nina.
Yeah.
What happened?
So there was an investigation after the student raised it with the university, and the investigation found that it was substantiated. But universities have another process where there has to be a disciplinary committee that determines what the disciplinary action is. And they found there was no sexual harassment and there was a lack of procedural fairness.
So I want to do two things here, because I know where Nina's going to come at this, and I agree. It seems that people think sexual harassment has to be a sexual act.
Yeah, or like extremely egregious touch-based things.
Yeah.
It's 2025.
Yeah, I know.
People should know better.
But the second thing is, and this is my concern, is how often do we see someone get into a dispute process where people try and make it go away? And they go, oh, look, no procedural fairness. Look, it's pretty minor. It's not really sexual harassment. Let's put this to bed because it's just too ugly for the brand. Now, I don't know if that's what they did, but I can't help feeling that in my mind. But of course, when you go to a Fair Work Commissioner, the Fair Work Commissioner is meant to have a generous view towards the affected employee.
Yeah.
He spelt out the evidence clearly, and you looked at it and they go, he's right. And then he, of course, went to the place which is so important, which is the power abuse, the difference in power between the lecturer and the research student. If his behaviour is like that and she is powerless, even if he had no intention of what he was doing, it's still sexual harassment. So, yeah, he didn't do very well with his unfair dismissal claim. It was chucked out, and so it should have been. The other thing it shows is Lee, who's the commissioner, said, I don't care if there was a procedural failure in this. This type of behaviour is so serious. I think Nina and we've spoken about this. The Fair Work Commission, doesn't matter where they're appointed from now, left or right of politics. If you have bullying or if you have sexual harassment and you fail in procedure, it doesn't matter, the case gets chucked out. So I think it's a great case. Perhaps we go on to our next case now. Steen and Hire a Hubby. Nothing could be funnier name given the basis of this case, isn't it? Can I just say to you,
That's true.
There was once I organised Hire a Hubby to come to our house.
Did you?
To do something. Oh. And my daughters just laughed and said, that is indictment of you as a husband, isn't it? When you have to hire a hubby to come to your house to do a job.
That's true.
Yeah. And they were right. Okay, so anyway, let's talk about this case.
Yeah, so this was a employee who went on a period of parental leave. So I think she was off for 12 months, made a request for another period of 12 months, and that was rejected.
So, and that's lawful, by the way.
Yeah. So, the business wasn't doing really well. They needed to make several cuts. In fact, I think they downsized to just the owner. Didn't communicate with the employee while she's on parental leave. I think she reached out and said, look, can we discuss my employment? And he said, oh, you were made redundant 2 weeks ago. But they
What a surprise.
I know, they never consulted with her, never informed her of the decision. And so no shock there that she won.
Yeah, it just goes to the heart of a genuine redundancy, doesn't it? The
It's
failure to
just
communicate and consult, But I think
to not even inform someone they were made redundant.
But Nina, how often do we have to deal with this, where when someone's on parental leave, forms a view, we should get rid of them, and nobody communicates. And often there's incredibly good reasons that should have happened 3 years ago as to why the person should have been dealt with. But out of sight is out of mind.
Yeah, but
I wanted to get that in. Do you like that?
Yeah, I do.
No, thank you.
But I think in this case, the owner said, the lack of communication meant she never intended to come back. But they're not casuals, you've got to communicate with them.
And they're your employee.
Yeah.
And if someone's on parental leave, you've just got a puppy and I ring up and check how the puppy's going. Do you know what I mean?
I don't know if that's the same thing.
Well, if you had a child, I'd certainly check it and see. I mean, I'd do it with a puppy. I'd definitely do it with a child. Anyway, okay, let's wander on to individual flexibility working. So, okay, Nina, we see this too often, don't we? This is individual flexibility arguments. This is AAMA and FLSA holdings. Walk me through the facts on this a little bit, because I sometimes feel I've misread this given what's occurred, but I clearly haven't.
Yeah, it was just shocking, because it's another one of those examples where someone is trying to make quite a reasonable, flexible work request. It was to take care of their child, and yet the manager and the business just did a hard line approach and just said no.
But it was worse than that, wasn't it? Because at that stage, they then started saying afterwards, so this is pure general protections, by the way. It's not how it was agitated, but it is pure general protections, because you're protecting the right of a caring responsibility and flexibility at work. What they then did is start saying, well, we need you at work more often.
Yeah.
They didn't say it beforehand, but from that moment on, both, I think it was the supervisor and the boss, just kept saying it to her.
Yeah, and then started making complaints about the employee's performance and raised concerns that you could hear baby noise in the background, like completely unwarranted things.
Can you see, this is just pure general protection. I know it wasn't the case, but a workplace right, and then acting to their detriment as a result of
then came back with a proposal which was like, you work more and there's no work from home.
Yeah. So I've chosen this case for a really good reason. That is, it's an absurd case, because it highlights, I guess, what Nina and I see in work in huge ways, the little bits of things that we see from time to time. But I really want to raise it because if you had a good litigant in this case who did bring a general protections claim and was harmed through the process, this would be a really big claim. This wouldn't be a pay 4 weeks, do that sort of stuff. This would be a big, big claim. All right. We've got an interesting case about stockbrokers coming up and restraints. Wallerman and Fortrend Securities, two cases collapsed into one.
Yep.
Fortrend is a stockbroking business. They complained that their employees, after they left and before they left, poached clients.
Yep.
There was no restraint, okay? They relied under breach of contract fiduciary duties, which are obligations that arise during your employment, not afterwards. The stockbrokers concerned, they raised questions that they'd had unlawful deductions of money.
And withholding of bonuses.
Withholding of bonuses. And what one of the arguments behind that is the owners said, but we can do that because it's in a policy. And the policy can be changed from time to time, even if it's to our benefit and their detriment. The court made very short work of that, which says what controls what you're paid is your contract of employment, not a policy. You might think that's not important, but if you want to have a look at short-term incentives and long-term incentives, they're commonly in policies. Therefore, how you implement those by contract is critical, and the language that you use. That's the only reason I've really put that focus in. But what I thought was fascinating is the court said, look, there's evidence here that they did create lists before they left, they thought about it, but they did nothing with it. Now, we see that all the time. And it's potentially a breach of fiduciary duty if they acted upon it at that time, okay? And a fiduciary duty is to act in the best interest of the business with honesty and not do anything to the detriment of the business. But there was no evidence they did anything other than that, and there's no evidence they took that list with them. And in fact, that list was known to them because of the nature of the work that they did. And then, yes, they did go and contact clients, and they took clients with them as well. And the court said, well, but you've left, so there's no breach, because the breach only arises if you did it whilst you were employed. Fiduciary breach, breach of contract, or corporations breaches that sit around that. It's only while you're employed, director, shareholder.
Or if you use confidential information.
And they say this is not confidential information. So I think when we talk about restraints, this is a really important case because it shows when you don't have a restraint for someone who is a key person who has goodwill in their hands.
What can happen?
What can happen?
It's just crazy though that they could just wait till they finish and then they can just go and poach the clients.
Well, just think about it. I don't want you to act upon this, but you know nearly all my client base.
Yeah.
Okay. I can't say to you just switch your brain off, Nina. Okay. I don't, and I.
But it's knowledge that I obtained working during the business. So how is it? It's weird that it's not confidential.
Well, no, it's not confidential because you've got to treat it as confidential. In other words, you've got to have a document that's confidential. It's got to be secure. You've got to demonstrate that it's always confidential in the manner in which you deal with it. There is a process to meet confidentiality, and that's those early cases. like Victorian chickens in those cases said, well, Victorian chickens, which is great, I just love it. I'll say it one more time, Victorian chicken. It was about where clients were on a delivery circuit and the person had all that knowledge and they went for confidential information. They said, but he knew it. It's not a breach. Okay, how can you lock his brain? But if you had treated it differently, it would have been confidential information. Okay. I think we're going on to a case which I think is really important. I'm just hoping we are going on to that case. Yeah. This is Hancock and Sydney International Container Terminals.
I think this is a great case.
I think it's a great case because it highlights, Nina and I have been talking about drugs and alcohol over the last, well, we do it regularly socially. No, sorry.
Oh my God, no, we don't.
But we've talked about drug policies and about the difference between zero tolerance and impact. But alcohol policies have been around a long time, okay? And alcohol policies can be zero, they can be 0.2. It's not an impact-based issue.
Yep.
Can be based on the nature of the business. Here they changed the policy from a threshold of 0.02 to zero, and they communicated that by texts, by emails, but there was no other proper consultation. A guy had a glass of wine before he came to his shift. He was initially tested a bit over 0.2 and then went at
0.017 after he had a confirmatory test.
Yeah, they terminated him.
For serious misconduct.
And so there was a couple of issues that were clear, and that is, was he in breach of this policy? And if he was in breach, what was the proper remedy of it? We didn't get to the second question because the court basically said the failure to communicate policies and ensure a person is competent in the knowledge and the impact.
We should say that the previous policy had a limit of 0.02, which he was under, and they had changed it to be 0.00.
I think I said that at the start.
Did you?
Yeah.
Oh, sorry, I must have missed that.
No, you just
Apologies.
she's stuck on the camera. That's your problem. Anyway, that's everything she says is true. I could say it a third time, but it'd just be silly. But the issue was, at the end of the day, he didn't meet the threshold under the original one. And the failure to communicate and...
No, he did under the original.
It's reversed.
Yeah.
But the issue here, the live issue, again with this case is, if you don't have policies where you demonstrate competence and knowledge of it, you can't enforce them.
Yeah.
Sending a text is not an answer.
Yeah, and it's specifically a text which said there's updates, but they're not taking people through it. And there were 2 Toolbox meetings, but they spoke about it for 3 minutes. Yeah. So they could not prove that anyone understood or followed it.
Competence and policies are pretty good. I want to move on to for our education clients to our next case. Morrison and State of Tasmania, I think, is a question that not only education but health service and a number of people deal
even
with.
councils as well.
Councils, where they deal with people who they know are aggressive and dangerous and they fail to do something because it's their service. They have to deliver that service. Yeah. This is a school that dealt with a non-mainstream school dealing with kids with special interests.
Yep.
There was a teacher who had been assaulted by one of the kids.
No. Let me go to the facts.
You want the facts?
Yeah, I'll
or do you want
my
story? Because my story's better.
Yeah, your story is better, but it's not quite correct.
Says so.
No, the teacher... No, in the past, so as in it caused him stress. He had previously had an incident with a violent student and had been subjected to threats and stuff.
By the way, Nina's right. Because I'm just now reading the facts of this case.
Yeah, because I summarised this case. But the main thing was there was an incident with 2 students who had gotten into a violent altercation, so much so that they blocked 4 lanes of traffic. They weren't in this special project, this special program, but when the school decided to readmit them, they said they were going to move them into the same building as the special program, and the teacher was quite alarmed at that and said, look, I don't think that is safe for the students and for the teachers. And the assistant principal and principal ignored his request to suspend them, and he went off on workers' compensation. He got diagnosed with adjustment disorder, and the department refused liability because they said it was reasonable management action. And that's the heart of this case, whether it could be reasonable or not.
It's close to what I was saying.
Yeah.
But can I say this agitates a whole lot of issues that sit separate from this under child safety as well. But the point of this is it is never part of a role to be exposed to violence. That's not an occupational health and safety issue. that's just no role can have as part of its role, you're exposed to violence. And this is the difficulty in police and paramedics and stuff, because they are, and therefore what are the protective mechanisms you put in for those psychological hazards? But in a school where you can't have those protective mechanisms and where people aren't skilled and in managing those things.
Well, they didn't even try. They put no security measures in place.
Nothing at all. So I'm putting this out there because it is common, and we're going to do this through the case study, where you have kids who misbehave, where you have parents who misbehave. And if we look at last year, we had 2 situations of parents being aggressive to teachers, where fortunately the principals in both cases did intervene.
Yep.
But I just want to put it out there. Teachers, health professionals and others, it is not part of their job description to be exposed to violence, and therefore the nature of the control under the hierarchy control must be elimination. Okay, or at least guarding and prevention, and that guarding might be physically by guards or by reviewing people's conduct, whatever it is, but they must be safe. There you go. I thought it was a great case, actually.
Yeah,
you don't often get cases.
It was an excellent case.
It's even better when you know the facts, I think. That's just my view. Okay.
On to the main topic.
Main topic. Nina, this is really your stuff, but we've seen, well, that's not me trying to get out of it. We've seen this first sentencing report come on occupational health and safety with 12 recommendations that have come out.
First time since the OHS legislation was enacted, actually.
Yeah, and these are my observations, then I'll let you break it out a little bit. There is this weird amalgam that sits in here. Some incredibly good things, but other just trash. And so there's this idea of restorative justice that sits behind it. Can I just say I embrace restorative justice. The idea of having victim impact statements I think is great. The idea of having conferences and then undertakings and things to try and heal somebody might work in some circumstances, others, but then the whole issue around undertakings is just nonsense. And then you come to the increase in penalties. And
they're significant.
And I think they're sort of deliberately hidden in the back of the document almost, but they are overwhelming. And then there's some, I think what you and I have been complaining about reckless endangerment for a long time. I'll let you talk more about that. But do you want to go through in those sort of areas what the changes they're suggesting and what's likely to happen with it as well?
Oh, I'm not sure about that.
Well, what's likely to happen with it is it'll go to government and everyone will get scared and it'll sit there, but it'll probably be rolled out at exactly the same time as psychological hazards and used as leverage. That's what'll happen with it.
Well, I think it's really interesting around the focus on restorative justice, because that seems to be the underlying principle that they've really pushed forward when you read the report. And actually, I would recommend you read the report. It was actually really good in terms of all the statistics and everything. But this focus on restorative justice, including this introduction of a new impact statement. So you would have your victim impact statements, which you normally have anyway, but now, more than that, people who, other employees who work for the organisation who could have been impacted by the risk can file an impact statement. Family members of the victim can as well, and all of this would be considered as part of it as well.
And can I say to you, our experience, and we've between us run hundreds of serious injuries and fatalities, is every time one occurs, there is somebody within the organisation who never comes back to work. So we underestimate the level of impact. Oh, I don't think we do, but can be underestimated. You're inclined to say, that's terrible, that person got injured, or that's the worst, that person died, that's shocking. But there are waves that go out and, these concentric waves of damage that is done. It changes people's worlds.
Oh, 100%. But I guess what I'm saying is all of this restorative stuff, I think, is definitely heading to higher penalties.
Oh, it is.
Because if you're getting 3-4 statements each time you're getting prosecuted, it is obviously going to aggravate
it is.
Whatever the sentencing is.
Well, it works two ways, doesn't it? It works towards higher sentencing and more serious sentencing to draw a line in the sand about what behaviour is accepted and not. And if we think about bullying and sexual harassment, you can see how it's going to work.
Yeah.
For this to be devastating.
Yeah.
But secondly, it's also driving you back towards the non-prosecutorial pathway of trying to get resolution to stop the hurt.
Yeah, well, actually, that links to the second recommendation, which is all about restorative justice conferences. So they want to have conferences between the offenders and the victims pre-sentencing and hopefully to work through some outcomes. And like you said, Andrew, they've done this in criminal jurisdictions before, and depending on the outcome, that could be a consideration for the sentencing as well.
And it drives behaviour before then. So people can't just put their lipstick in and come in and be nice. They've actually got to have shown the stuff we train people on to actually connect with the family immediately, make sure you're there so that the person, when they come through the room, is actually seeing a person they care about and understands it. But I just put this now because we go to the next topic of undertakings. This is already time is drifting. Most prosecutions take at least 2 years till they get to court. That's 2 years in which somebody is hurting as well.
Yep.
So great idea. The issue is how do we compress this? And unfortunately, the next recommendations draw it out further.
Yeah, the big thing that they seem to focus on is this idea of health and safety undertakings, which I hadn't heard about before, because we're used to, fines, we're used to imprisonment, we're used to enforceable undertakings, but health and safety undertakings are something else entirely. And they've always existed, it's just they're super underutilised. Rather than making an arrangement with WorkSafe, it's actually a court-appointed undertaking. And the reason why it's not utilised very much at the moment is because the court cannot force a employer to be subject to it. They have to opt in, and no employer is, because it's extremely expensive and onerous, but they are pushing for it to be more common and the preferred sentencing option.
So there's 3 options really, isn't there? There is undertaking, enforceable undertaking, plea or finding of guilt.
Yeah.
Now, let's start. Finding of guilt is a precise and quick method of getting to something without a lot of cost and being tested against what is reasonably practical, if that's the test. So you can contest back to what is reasonably practical. There is no higher obligation cast upon you. And the cost and outcome is less than step 2, enforceable undertaking, where there are huge costs. The nature of the enforceable undertaking invariably goes beyond reasonable practicability, and in doing so creates liability for officers, which is why once in a blue moon we do one. But once an officer signs an enforceable undertaking with a threshold test that is too high, because WorkSafe won't go low, then the inevitable incident that occurs afterwards points a finger at that officer, and you're off to reckless endangerment land with the officer. Undertakings
are very similar.
They're just looser and more dangerous, because the court's told you you've got to do this for a couple of years.
And if you do anything wrong, it doesn't have to be related to that. If it's essentially a commitment that you will not breach OHS in any way.
So just imagine you're there for forklift, traffic style accident, management of traffic accident. So you go, all right, you do use 4 forklifts. No, nothing's going to happen for 2 years. But we also work at heights. No, nothing's going to happen there. So I'm in the construction industry. Would I in my right mind give an undertaking knowing that the people I employ are likely to breach rules that I put in place? And so the likelihood of incident, not injury, the likelihood of incident is highly likely. Why would I give an undertaking? So there's a level of fantasy in all of this which doesn't connect with what the real world is.
Yeah, I don't know if it's going to be super practical. But it is probably one of their bigger focuses.
No, and it's part of the restorative drive.
Yes.
And that's also reducing the cost of justice. Freeing up magistrates. It's doing a whole lot of stuff. But the answer is if they just go straight to plea, it frees up magistrates too. That's
crazy.
Okay.
Just finally, quickly, increase in maximum penalties to 10 million in Victoria for primary duty breaches, and that will bring us in line with a lot of the other jurisdictions, and it's essentially supposed to be a deterrent. I think the biggest, most interesting change is around reckless endangerment, where they agree that it's just not used very well because the threshold is so high. It's easier to prosecute under industrial manslaughter. So they're proposing that it can only be charged against individuals, not against PCBUs.
We both agree on this.
Yeah,
this is something we've been saying every time we get on here. We say it's crazy. It's easier to prosecute industrial manslaughter than because of the subjective element in it. Why have they got it? But for something where you can put someone in jail as an individual, yes, the threshold test should be a little bit higher.
Yeah, I agree. And it's going to be 10 years imprisonment.
Yeah. So, the penalty stuff, the other thing is there is a direction that any penalty goes to the coffers.
Oh, sorry, yes, to WorkSafe. And also they're trying to address phoenixing and stuff. So directors who repeatedly engage in OHS breaches will get issued with notices so they'll be personally liable.
Yeah, which is a nice one.
Yeah.
But the one about directing at the coffers goes back to the old New South Wales, the DM award at the end, which would take it to WorkSafe. And WorkSafe in New South Wales, under the positive duty legislation about 10 years ago, were actually in profit. I think
WorkSafe here is definitely not in profit.
But I guess I'd just be wary of what's going on here, because once again, we're getting an increase of penalties. We've got a work cover scheme that's broke. And I keep seeing the government putting out its hand to grab money back. And that's not where it should. I'm sure a certain amount should go towards them. I can understand that. But the whole amount, wouldn't it be better to say to the injured worker to whatever, or to actually aid the prevention of forklift injuries? Why would it go to WorkSafe, who have almost zero educative role?
I think, though, the current law has it go. It's just something about it not being clear enough or something. Yeah, it's a bit weird.
It is a bit weird anyway.
But definitely it'll be interesting to see which ones they implement, and we'll keep you updated.
And look, middle of next week we'll have Workplace Watch, which deals with psychological hazards and this issue, where we really get into some depth with it. So watch out for that. We'll send it out to you. Let's go to the case study.
All right, so Jean was worried. She had been the principal for 3 years at Gatherings Grammar, a suburban private school. Gatherings had around 1,200 students, ranging from 4-year-old kindergarten through to VCE. It had been a rough ride modernising the school. The board was, at times, resistant to any change that impacted a coterie of professionals in the parent group or their children who were closely aligned with the old guard of teachers and continued to espouse the 3 Rs, dismissing more modern concepts of well-being. This also created an inner group whose children were feted and protected. Feted and protected.
Second word.
While everyone else was treated less generously. We have now records of you bullying me. Jean had to deal with Conrad Taylor, a 17-year-old boy whose parents owned the local dental clinic. They were old grammarians and well connected with the old crew of teachers. Since year 10, Conrad had terrorised the vulnerable students in his class and more recently had threatened and intimidated Marjorie Dean, the year 12 English teacher. Conrad was on a football scholarship. He was strong, athletic and fierce. Ms. Dean felt intimidated and scared. She had complained to Jean, and a meeting was facilitated between the parents, Conrad, Jean and Miss Dean. Mr. Taylor, Conrad's father, verbally abused Conrad during the meeting, then turned his ire on Ms. Dean, calling her weak. In the end, it was agreed that a behavioural program would be developed in collaboration with the school, psychologist Ms. Dean and Conrad. The plan was agreed upon and signed off by the parents, but the behaviour continued. Jean had threatened to suspend Conrad, and shortly after she received a lawyer's letter suggesting she was in breach of the admission contract and the Education and Training Reform Act. The letter claimed she was violating safety laws by making the school unsafe for Conrad, who, according to the letter, was being bullied by the school. Jean was stuck. The chair of the board had approached her and asked her to be circumspect in dealing with the Taylors. She knew of 3 children who were terrified of Conrad, 2 of whom were exhibiting signs of stress and anxiety, struggling to even make it to school. She felt it was dangerous to allow Conrad to remain at the school.
There you go.
Ooh, that was a long one.
It was, yeah. That's one of those late night ones from me. Okay, questions. Should Jean have acted earlier under child safety legislation?
Yeah, well, if it's been happening since year 10, I think Jean is in trouble. They're supposed to notify within 3 days.
I think that you and I deal with this in so many different environments, in health and others, but there is a bit of a threshold before child safety legislation kicks in, and that's where there is serious risk of harm. And I think here I've deliberately painted the picture as very open, but if any of those kids are suffering any form of psychological injury or the potential of a psychological injury, it's definitely notifiable.
But even before that, even before you've got confirmed evidence, if you've got a reasonable suspicion, that is enough to trigger your obligation, and a principal would have to notify, otherwise they'd be breached under reportable conduct legislation.
Yeah, so and that would be things like being aware the child is not wanting to come to school, being aware that the child has had some physiological effect like increased anxiety.
Or there's violence.
Yeah, there's violence, yeah. So interesting. I did that. Under safety law, of course, the obligations kick in before child safety. So the moment something creates a psychological hazard, you must intervene.
Yep.
So
Jean is 2 years late.
2 years late and bordering on reckless endangerment, to be perfectly honest.
I think so.
Yeah, because she's aware of
which is the second question. What are the risks to Jean in the school?
Well, I just said that in safety law. I just thought I'd check that in anyway, but it's all right. So let's talk about Jean in the school.
Well, you were answering the question.
I like to answer questions. That's what I'm paid for in 6-minute units, all right?
So reckless endangerment.
Well, let's start off with primary duties.
Yeah.
Is the school in breach of its primary duty for failing to do something? Absolutely.
Yes.
Is Jean under...
Even though they're not employees, they've got duties to others.
Others, that's right. So is Jean in breach of her due diligence obligation under Section 144 and her personal obligation under Section 25, which are similar?
Yes.
Yep, absolutely. So as far as liability goes, it's a really easy run for WorkSafe at this stage. Whichever jurisdiction in the same law applies, except of course the due diligence is much easier to prove than everywhere else but Victoria. It's an objective test. Next question though is, does it reach the reckless endangerment threshold?
I think she has been ignoring it because she's organised for interventions, but it hasn't really addressed the issue or done anything.
That's the heart of reckless endangerment. So
it's been insufficient.
She's aware of it. She's getting pressure from others not to do stuff. That doesn't change her liability. It does put the relevant board members at a high level of risk, but it doesn't change her liability because once you're aware of the risk, it's your indifference or carelessness in respect to that risk. So you must take the right action or you trigger it. Now, she does have the subjective knowledge, which is the hard thing to get over the line in reckless endangerment. And I suspect because of who she is in the school has it as well.
Yeah.
Yeah, but there's no death, so we don't get to industrial manslaughter.
You sounded upset about that.
Oh, that would give me something to show off about.
Would Ms. Dean have a workers' compensation claim?
Yes. No reasonable management action, nothing, no defence at all. If she does develop a psychological injury...
And they continue to expose her to it as well. Yeah. If Ms. Dean took personal leave to avoid the impact of Conrad despite having made complaints about her own safety and the school did not take steps to make her workplace safe, could she have a general protections and discrimination claim? Could she argue that if they refused to remove Conrad, she had been constructively dismissed?
So I thought
that was a long question.
I know, it was late at night. But I think it's a good question. Gee, we're over 30 minutes today, aren't we? But yes, the answer is general protections are live whether you're terminated or not. She's raised a workplace right and they've failed to deal with it and they've actually made her unsafe, so they've acted in a manner that makes it so tick. She's raised a protected attribute and they haven't made reasonable adjustments, tick discrimination. And yes, she can't come back to school. There is no way around it. So in a way, she's been constructively dismissed. I don't think that case would be successful. I don't think it'd be run, but it was just an interesting idea I had when I was out there. What's the last one?
That's it.
That's it.
All right. Thank you.
Have we done that? Yeah. Oh, cheers.
Thanks for joining us. Give us a thumbs up.
Give us a thumbs up. Bye.
Bye.